say more. It would help if you're going to split the times, 10 minutes, 5 minutes, that kind of thing. Thank you.
Thank you.
Yes, ma'am, let's proceed.
May it please the court, Jennifer Sunderland for Noel Pagan. This case again requires this court to interpret the crime bill enacted in August of 2012 with respect to certain sentencing reforms. In this case and in the companion case of Commonwealth versus Bradley, this court needs to determine whether or not a defendant whose case was pending on the date of enactment and effective date of the crime bill, August 2nd, 2012, is entitled to the sentencing reforms that were enacted within the crime bill. In Commonwealth versus Galvin in August of 2013, this court determined that one of the primary purposes of the crime bill was to significantly reduce the sentences to be served by individuals under the minimum mandatory provisions of a wide range of drug-related offenses.
But Ms. Sunderland, here isn't the issue, at least on the surface, it isn't reducing the sentence, it's changing the nature of the crime.
Well, I guess, so it depends on how the court characterizes a school zone. It's the defendant's position that a school zone is not, in fact, a standalone crime, but it's a sentencing enhancement that is necessarily linked to a predicate drug offense. An individual cannot be charged with the school zone without also being charged with an underlying offense. So in that respect, the defendant's position is that the character is more like a sentencing enhancement than a standalone crime. And I would suggest that the court's rationale in Galvin, which gave an assessment of the legislative intent with respect to the crime bill, applies equally in the context of a sentencing enhancement that is based on a now reduced school zone. For example, in Mr. Pagan's case, the conduct at issue occurred 700 feet away from a daycare center. Under the old version of the law, that would be within the school zone. Under the version effective on August 2nd, that would put his conduct outside of the school zone, which is now 300 feet.
Does it matter that in Galvin it was really dealing with a crime and a sentence that was specifically mentioned in the 2012 bill? I mean, you know, reducing from 5 to 3 for those particular crimes. And here, we just don't have anything like that.
I think what the court is getting at is the explicit language in Section 48, which is the so-called retroactivity provision of the crime bill. The Commonwealth takes the position in this case that because Section 30 and Section 31, which were the sections in the crime bill reducing the school zone and also making the school zone only effective between 12 a.m. and 5 a.m., that because it's not mentioned, it's therefore assumed that the legislature didn't intend retroactive effect. I'd suggest that Section 48 is useful for this court's determination because it nonetheless provides insight into the legislative intent, which is ultimately the question that the court has to determine under the principles of statutory interpretation set out in Chapter 4, Section 6. Taken in conjunction with the title of the act, the preamble, the fact that it was to take effect immediately, Section 48 shows that the legislature intended that the effects of these sentencing reductions would be both backward and forward-looking. And I'd suggest that Section 30 and 31's absence from that section shouldn't be fatal to the defendant's position because Section 48 explicitly dealt with eligibility for parole, good time credits, and other reductions in sentences, sort of procedural mechanisms by which sentences were reduced. In 2010, the legislature enacted similar provisions for parole eligibility for school zone offenses.
So this really depends, though, I think, on our agreeing with you that this is a sentencing enhancement rather than elimination by the legislature of something that once was a crime, a repeal of a crime. I mean, that, and I guess I'm surprised that you didn't consider that, or did you and discard it? You thought this was the best argument to make. It's sentencing, and therefore it falls within the whole notion of sweeping it into Section 48. But if it's not, if we don't agree, what then? If we say, you know, that happened earlier, and it's not sentencing, it's a crime. It's a standalone, it's a separate statute, there's an element now missing.
Mm-hmm. Well, frankly, I don't necessarily think it makes a difference whether the court characterizes the school zone offense as a sentencing enhancement or whether it views the legislature's language in the crime bill as being essentially decriminalization of conduct that occurs farther away from the school zone. I don't think it matters because of the fact that ultimately what is at issue is whether or not is what the legislature intended, and whether or not to prosecute somebody after August 2nd, 2012 for something that would no longer be considered a crime would be inconsistent to the manifest intent of the legislature and repugnant to the context of the same statute. Ultimately, I think the issue for this court is what section of Chapter 4, Section 6 governs this issue. If it's the proviso, then I'd suggest that the legislature intended for these sentencing reductions or this decriminalization of the closer school zone to take effect immediately, to take effect when a defendant's case was pending on the date of the statute's enactment. And I would further suggest that essentially this court has to determine which case governs this. Is it Dotson or is it Galvin? And I would say that the statute involved in Dotson is distinguishable from the crime bill because there was an absence of legislative intent in the statute which this court had to interpret in Dotson. Dotson involved a sort of omnibus budget bill where there was a decriminalization, or sorry, elimination of a period of incarceration for disorderly conduct. In contrast to the statute at issue in Dotson, there are indicia of legislative intent with respect to the crime bill in that it was supposed to take effect immediately, including for individuals already incarcerated under the older minimum mandatory sentences, and I would suggest, as this court found in Galvin, for those who had pending cases. The legislative history further supports this interpretation, and this court has access to legislative history under the crime bill that it did not have access to in Dotson. Almost from its inception, this bill was intended to be a compromise between making certain crimes subject to harsher penalties while also reducing periods of incarceration and accordingly rates of incarceration for lower level drug offenders. To apply the school zone here, to find that, for example, Mr. Pagan and Mr. Bradley are still to be sentenced under the old minimum mandatory sentences would not serve the intent of the legislature with respect to the enactment of the crime bill. And I know that the court has access to the amicus brief that was filed by Barbara Dugan and Pham, and in that case, the amicus brief discusses Dorsey, which is the Supreme Court decision from June of 2012, which interpreted the Fair Sentencing Act. This case is relevant for this court in that it provides a roadmap to a similar statute under federal law, and federal law has a similar federal savings statute that sort of mirrors Chapter 4, Section 6. And Dorsey, as we know, deals with the interpretation of the Fair Sentencing Act, which reduced the crack cocaine powder sentencing disparity from 101 to 18 in 1, and this was taken in conjunction with the sentencing guidelines. Under that case, federal law also contained a similar savings statute, and the court found that the Fair Sentencing Act's more lenient penalties applied to offenders who incurred the penalty prior to the statute's effective date, but who were sentenced after, which is essentially the situation that mirrors what's at issue here. The court was persuaded that there were 6 reasons to apply the more lenient sentences to a defendant whose case was pending. Among them were that principles of statutory interpretation suggested that even in the absence of express words, which is similar to the situation here, we do not have express words from the legislature as to whether or not the statute has retroactive effect for pending cases. But the court in Dorsey found that even in the absence of these express words, that principles of statutory interpretation permitted application of the more lenient penalties. In addition, the Sentencing Reform Act itself and the sentencing guidelines specifically dictate that new guidelines take effect immediately, even if the penalty, even if the crime leading to the sentence is incurred previously. Third, the court found that the language from the Fair Sentencing Act indicates that Congress intended that the principles be applied in the context of the reductions enacted by the Fair Sentencing Act. And the court also found that to apply what would now be obsolete minimum mandatory sentences to pre-act offenders would create a series of sentencing disparities that were among those that the Sentencing Reform Act that created the guidelines was enacted to prevent. We would have the same situation here, where we would end up with a class of offenders whose cases were pending on the date of the statute's enactment, who would not benefit from the crime bill's sentencing reforms. And this, both Pagan and Bradley would argue, are in contravention to the legislature's intent with respect to the statute itself. And the court essentially in Dorsey found that there was no suggestion that Congress intended otherwise, that Congress wanted the older the older sentence to apply to cases that were pending. And this court has to answer that same question here. And ultimately, the defendant's position is that the issue with respect to the school zones is more like Galvin than it is like Dotson. And that it's the proviso in Chapter 4, Section 6, stating that the general rule, obviously, is that penalties are incurred on the date of the conduct, unless to find would be in contravention to the legislature's intent and inconsistent with the manifest intent of the legislature and repugnant to the context of the same statute. If there are no more questions, I will rest on my brief and cede the remainder of my time to Mr. Bradley's counsel. Thank you.
Thank you. Who's next?
Good morning.
My notes say that we're going to hear from Brooke Lane. Are you Brooke Lane?
I am.
All right, thank you.
Good morning.
Good morning.
May it please the court, my name is Brooke Lane. I appear before you as an assistant district attorney for Middlesex. I am the attorney assigned to the matter before the court. First of all, the defendant's argument is wrong because it ignores the plain language in sections 30 and 48, and it encourages this court to take a position that would lead to sentencing disparities similar to those that this court sought to avoid in its decision in Galvin. Pursuant to Dotson, this defendant incurred his punishment under the school zone law as it existed on the date of his offense, not on whatever future and arbitrary date he resolves his matter. Under Chapter 4, Section 6, second paragraph, Section 30 does not affect his penalty because the date of offense, again, occurred prior to August 2nd, 2012, which was the effective date of Section 30. Additionally, this construction is consistent with the manifest intent of the legislature, as evidenced by the fact that they excluded Section 30 from Section 48.
Excuse me, but apart from that specific fact, considered as a whole and looking at the history, weren't they trying to affect both two things? Making sure that people leave jail sooner, and that certain people don't come into jail. So, restricting what the penalty was to a smaller, right, 300 feet.
Yes.
How is it consistent if you let people out sooner on parole, but then at the back end, and let them in on the front end?
It is consistent because denying retroactive application in this case draws a bright line based on date of offense and not, again, on the arbitrary date of resolution. It is more equitable to group people together based on when they committed the crimes under the school zone law as it existed at that time, rather than categorizing them based on when they
Why is it
resolved
more
the case.
equitable if the legislative intent, if, it was a big if, was taking the act as a whole, was to actually treat them differently? I mean, why is it more equitable? More equitable to the DA? I mean, to
It's
whom?
more equitable to treat people similarly situated in the same manner. The defendant has mistakenly argued that people with pending cases in Galvin are similar to people with pending cases under the 2012 crime bill. If this bill is, or this section is applied retroactively, the people who have resolved their cases prior to August 2nd will receive a different sentence than people, even co-defendants, that chose to have a further date, whether it was extending their trial or simply not resolving their case until after August 2nd. And in effect, this defendant is asking for relief that individuals will not receive under Section 48. He's asking this court to decriminalize his conduct. Section 48 does not change sentences. It is not vacating convictions. It is simply offering post-resolution, post-conviction
Well, I
relief.
take it he might still be guilty of possession of cocaine,
Yes, that is possible.
just not within 300 feet of a school zone.
If this law were to be applied retroactively, it's
And why
changed.
isn't the school zone piece a sentencing enhancement piece?
Because it's a separate count, it requires a separate element. The
That's
Commonwealth
true,
can
that's
still-
true of, I mean, sentence enhancement is also a separate count, isn't it? I mean, can't get tried with it has to be done separately.
Correct. In a situation such as an OAS subsequent or an OUI subsequent, that is true. But because we have a different element that we have to prove here, and because it is brought on a complaint as a separate count here, it is a separate charge that the Commonwealth can go forward on independently.
So it's a separate charge, but the old law's been repealed. There's no longer, as of a certain date, a crime, right? Under your view, there's no crime to do what this defendant did outside of 300 feet. It's not a crime anymore.
After August 2nd.
Correct. So when he goes to trial, he's going to trial on a complaint that asserts that he committed a crime under when there's no longer a statute. So that's one, correct?
Correct.
Is there any case decided in connection with it's Chapter 4, Section 6, that ever has held, apart from a sentencing kind of context, where we're talking about a repeal in effect as an amendment, a repeal and then a reenactment of the same scheme, except that the sentencing has changed? Is there actually any case in which the legislature has said, nope, that's not a crime?
I believe
And under
that,
the rubric of that statutory repeal statute, they've gone ahead and just charged anyway?
I believe there was a 1972 case, Commonwealth versus Yee, which addressed that issue, where the defendant was indicted under a heroin-related statute that was
Right.
repealed after the date of his offense. And the court found, applying the non-repealer statute to that case, that that defendant could still be tried for his conduct under the heroin-related law as it existed on the date of his offense. It did not relieve him of his criminal conduct, which is what this defendant is asking to do, and is inconsistent with the manifest intent of the legislature here.
In that case, there was still criminal conduct, but it was just differently treated?
I don't believe it was differently treated. I believe that the statute was overhauled. And I don't remember the exact details of what the changes were, but I do know that that defendant moved to have his case dismissed because the chapter and section that he was indicted for violating was repealed. And so he therefore made an argument that he can no longer be held criminally liable for his conduct because the new chapter and section was not in existence and the one that he was indicted under was no longer in existence either.
Well, it was a repeal and replacement with a new scheme, which is probably what Chapter 4, Section 6 was designed to address, because for many cases, there isn't merely an amendment, but a repeal and then a reenactment, and there was a little space in between where there was nothing, right?
Right. And I believe that the case law, which interprets the second paragraph of Chapter 4, Section 6, states that the purpose of the second paragraph is to preserve an offender to liability for his conduct even after legislative amendment of the chapter and section that he's been charged under.
There is some broad language, but I'm just wondering if there was an actual case where there was no longer a crime. But I take it that you're relying on Yee for that. Thank you.
So is it your view that this is not a matter for us to interfere with? It's simply a matter for the prosecutor to exercise sound judgment as a matter of discretion as to whether it's fair and just to punish somebody for a crime that the legislature says is no longer a crime in the future?
I don't think that the legislature has said that it's no longer a crime. They've simply changed the liability. And applying this court's ruling in
Well, that's
Galvin,
inconsistent with what you said. You said this is a separate crime. Now you're saying it's a sentencing enhancement.
and they've changed the elements of that crime. They've simply changed the liability by
So,
reducing it.
But
so
the
if
same
it's
conduct
700
now
feet,
is-
it's
is-
not a crime.
If it's over 300 feet after August 2nd, that is no longer triggers a school zone violation, which I would still argue is a separate crime.
But you're still saying as a matter of prosecutive judgment, it's still appropriate to prosecute somebody for something which is no longer a crime.
Based on the fact that they committed that crime under the school zone law and under Dotson, they incurred their penalty under the law that they violated at the time of their offense.
They didn't incur the penalty until you prosecuted.
I believe that the interpretation under Dotson is that her penalty in Dotson was set based on the possible incarceration for 6 months because that was the penalty at the time under the disorderly conduct statute. Once I believe that the change was made in that case and reduced the potential incarceration down to fine only, the court still found that she had already incurred her punishment or potential for incarceration based on the fact that that was the statute as existed when she violated it.
Mr. Brook, Mr. Lane, your time is up.
Thank you.
Thank you, sir.
SJC-11457, Commonwealth versus Zachary.
Good morning. My name is Steve Pagan. I'm here representing Zachary Bradley. I won't repeat much of what Attorney Sunderland has argued since our arguments are essentially the same. I would point out briefly that in taking a look at the cases that have interpreted Chapter 4, Section 6, it's important to look at each of those cases on their individual merits. Commonwealth versus Yee, which was cited by District Attorney's Office, is a case in which this court grappled with the legislature's specific intent to change the heroin possession law, but because of the way the statute was enacted, there was a period of time in which, for a period of a month, a defendant might be found not guilty or not liable for possessing or distributing heroin. In that case, the court could take a look and clearly interpret the legislature's intent in that statute, which was not to create a vacancy for a month and allow the distribution of heroin legally. In this particular case, the amendment to Chapter 192 and the specific provisions dealing with the area of the school zone, as well as the area dealing with the time of day when the offense occurs, is the only section of the statute which the legislature did not address in terms of retroactivity. But if you take a look at the history of the legislature and the background information that the legislature had at its hands when it was reviewing and arguing over this case, it's clear that the intent of the statute was to both reduce the incarceration for nonviolent offenders, and as was pointed out in the amicus brief, the school zone cases are those types of cases in which since the mid-90s up until to date, they were either the first or second most mandatory sentences. It is inconsistent with the legislature's intent to leave that particular portion of the statute and continue to sentence individuals to mandatory jail sentences while addressing the rest of the drug cases by reducing sentencing and giving early releases.
So, but what, go ahead.
Oh, I was just going to ask, you made an argument that it makes no sense to extend the early release under sections 12 to 29 to those who've already been convicted and sentenced under the former version of the law, while denying the benefit of section 30 to the defendant. And I wondered what you meant by that. Did you mean that somebody convicted under, if he were convicted now under the old version of the statute, he would not have the benefit of sections 12 to 29?
No. If he were convicted under current statute, under the
Old
old
statute.
statute, he would have the benefit.
He
of-
would have the benefit.
Because those sections, that was amended in 2010 to provide those benefits.
Correct.
So your argument is that would have been essentially duplicative to put that in section 48 because those benefits had already been provided.
Yes.
Counsel, we have to leave it there.
Thank you.
Good morning. May it please the Court, John Bossé for the Commonwealth, Berkshire District. Respectfully, the Commonwealth submits that the reduction in the school zone distance is not retroactive to the defendant's case.
But would you agree with us, or agree with me, I should say, that if section 48 had included a reference to 30 and 31, it would have made no sense, would have made no difference, because these benefits had already been provided for people convicted under school zone mandatory minimum sentences, correct?
Correct.
All right.
However, Section 48 does not advance the defendant's argument because Section 48 specifically excluded Section 30. It included, as you know, Sections 12 through 29. And also...
But I guess my point was it really wouldn't have made any sense to include Section 30, would it?
Well, actually, it would have because...
Because we're talking about people who at the time of the passage of the act were serving a sentence under, right? I don't want to distract you. Go ahead.
If this court were to conclude that the reduction in the sentence, the reduction in the distance is retroactive to the defendant's case, it would create disparities. It would create disparities between two people who commit the same crime on the same date, based solely on the date they happen to be convicted. In other words, it would go against the sentencing policies and procedures under Chapter 211E, Section 2, which seeks to avoid disparities in sentences.
You say that, but doesn't your office and every office exercise judgment in deciding when to proceed with the school zone? Aren't there some persons who get a school zone and some don't?
That's correct.
So why is this disparity any different from what the prosecutor himself or herself does consistently?
But that's purely the prosecutor's discretion on whether or not they wish to dismiss the school zone. Again, under the rules of construction, it's the date of offense which controls.
Okay, I understand that, but it's a little bit hard to get up on your high horse and say we can't treat people differently when prosecutors do all the time with regard to school zone, and according to some data, do so on the basis of race or ethnicity. Isn't that the concern that the legislature had, that the school zones were being applied in a manner that was detrimental to those who lived in the inner city versus those who lived in suburban and rural areas?
You're correct, Justice Gantz. That was a concern when you review the legislative history, when you review the debate and the oral testimony concerning the crime bill. However, that concern begins with individuals who commit the school zone violation starting August 2nd of 2012. Prior to that, again, yes, it's prosecution discretion, but if the prosecutor wishes to proceed under 1,000 feet, then they can. I think the court understands the Commonwealth's position. Unless there's any questions, the Commonwealth will rest on its brief.
I just have one question. I just want to see if I understand this. Put aside for the minute Justice Cordy's point that it wouldn't have made any sense to add this into Section 48. But if the legislature had, right, you would agree that your argument would fail in the sense that they could have committed the offense on the same date, but if Mr. Bradley wasn't tried, he would have the benefit of it while somebody else wouldn't, who had been convicted before August 2nd, correct?
I guess I'm a little confused with the question. If they had included Section 30 in Section 48,
Right.
then wouldn't the defendant who had already been
Well, so
convicted?
would that persuade you that actually that the legislature did mean to have this apply to people whose cases were pending?
But they didn't include Section
Well,
30, yeah.
Right. But if they did,
If they did,
you could still, I'm just trying to
But
get to the point that you would get to the point where you would still have people who might have committed the offense on the same date but being treated differently.
correct, and wouldn't that create the situation that this court was concerned with in Galvin? Am I wrong there? Because if they did include Section 30, then the argument from Mr. Bradley would be he's being treated differently than people who had committed the crime before August 2nd of 2012 and were currently serving a sentence. So this is the reverse of Galvin, where we're trying to avoid somebody who was convicted and sentenced before August 2nd of 2012 for the 1,000 feet violation being treated differently from Mr. Bradley and Mr. Pagan.
All right, thank you very much.
Thank you.